Hi everyone, hope you are doing well. This is Professor CA Karthik here. Today we are going to do the CA Inter question and answers of the company law chapter called as Incorporation of Company, which stretches from section number 3 to section number 22 of the Companies Act 2013. Okay, so we are going to do this chapter and we'll be covering the questions given by ICAI in its RTPs, mock test papers, and past examination papers. Let's see the questions now. Red Limited was incorporated on 1st April 2016, is facing severe effects of depression of the economy. Owing to its bad financial status, most of the members have started withdrawing their company, their holding from the company. The company had 250 members on 10 January 2021. By 15 Jan 2021, 244 members had withdrawn their holding. No new member has invested in the company after 15 Feb till date. Now, Mr. A, an existing member, has approached you to advise him regarding his liabilities in such a situation. Now, let's look at this situation. See, the company was incorporated on 1st April 2016, and here they have given the date as 10 January 2021. There were 250 members in the company. Now, what has happened is within 5 days, 244 members have withdrawn. This company, being a public company, needs to have 7 minimum members. However, in this case, they have only 6, that is 250 minus 244. And they have clearly said here that no new member has invested. Now, whenever the number drops below 7, the company should try to bring in more members, and for that, the company law gives 6 months time to do so. If they fail to bring in to the minimum number of members, that is in this case 7, then after 6 months, any debt that the company takes, the members will be severally liable. Members will be severally liable. Okay, they'll be severally liable. It means that the debt will not be required to be paid off by the company. The members will have to pay the debt because they did not increase the number of members to the minimum limit. That is, in the case of public company, it is 7, and in the case of private company, it is 2. Okay, and in this question, they have given in relation to public company. So that is how you will deal with this you will deal with in this question. However, there is one more small thing that you should remember. The members will be severely liable. No, they should be aware of the fact that the company has been running with less number of members. Okay, they should be cognizant of the fact. That is what the lawmakers have said. They should be cognizant of the fact that the company is running with less number of members. You see? Okay. Next one. What is the minimum number of persons required to form a private company and a public company? Explain the consequences when the number of members falls below the prescribed limit. Private company, the number is 2. Public company, the number is 7. And what happens if then the number of members falls below the minimum prescribed limit is already explained here. So it's a similar question. Okay. Next one. XYZ, a one-person company, was incorporated during the year 1920 with an authorized capital of 45 lakhs, 4.5 lakh shares of rupees 10 each. The company was fully subscribed and paid up. The turnover of the company during the year 1920 and 2021 was 2 crores and 2.5 crores respectively. Promoters of the company seek your advice whether XYZ OPC can convert into any other kind of company during 2021-22. Please advise. That is what they have said here. Now see, they are planning to convert this company into any other kind of company. When they say any other kind of company, there are three possibilities that come out. Okay. First is you can convert this company into a public company, or you may convert into a private company, or that they may be talking about Section 8 company. Now see this. Whenever a one-person company wants to convert, can they voluntarily convert? Yes, the answer is yes. So the question is, sir, why are they given the turnover and the paid up capital regarding all these areas? After the amendment of this matter, this is now an irrelevant part. Okay, so now it is irrelevant what is the paid up capital turnover. Any one-person company can voluntarily convert into a public company or a private company at any time. However, they cannot convert into a Section 8 company. They cannot convert into a Section 8 company because one person company will be running for profits, and Section 8 company, as you know, is a not for profit organization. Easy to understand, simple. Okay. Next one. Naveen incorporated a one person company, making his sister Navita as the nominee. Navita is leaving India permanently due to her marriage abroad. Due to this fact, she is withdrawing her consent of nomination in the said one-person company. Taking into consideration the provisions of the Companies Act 2013, answer the questions given below. Okay. If Navita is leaving India permanently, is it mandatory for her to withdraw her nomination in the one-person company? Second part is, if Navita maintained the status of resident of India after marriage, then can she continue her nomination in the said one-person company? Now understand this. Earlier, there was a requirement that a person should be an Indian citizen, also he should be a resident in India, all these things were there. Now, the only requirement is that the person should be an Indian citizen. That is it, Indian citizen. And if a person is an Indian citizen, and in the law they have said whether or not that person is a resident, okay, or resident or otherwise, it means that person can be resident or not a resident. So you will understand that earlier this residential status that was there, residential status we should check, and only if a person resident in India was allowed to be a nominee. Now this is not there anymore. So here, Naveen's sister Navita is leaving India permanently due to her marriage abroad. Due to this fact, she is withdrawing her consent of nomination in the one-person company. Taking into consideration, they have said if Navita is leaving India permanently, is it mandatory for her to withdraw her nomination in the said one-person company? The answer is no. It is not required for her to withdraw her nomination because she is an Indian citizen. Okay, so not required. And next, they have said here, and we have to assume here. Okay, she is an Indian citizen. Okay. Next one. If Navita maintained the status of resident of India after a marriage, then can she continue her nomination in the said one-person company? The answer is even if she maintained the status of a resident of in India or not, even if she doesn't maintain, still she will have the right to be the nominee of the one-person company. Easy, okay. Next one. Mr. Raja, along with his family, running successfully a trading business, is capable of developing his ideas and participating in the marketplace. To achieve this, Mr. Raja formed a single person economic activity in the form of one person company with his brother Mr. King as his nominee. On 4th May 2021, Mr. King withdrew his consent as nominee of the one person company. Can he do so under the provisions of the Companies Act 2013? That is what they have asked. Can the nominee withdraw his consent? The answer is yes, no problem at all. He can withdraw his consent, no issues. Examine whether the following individuals are eligible for being nominated as the nominee of the one person company as on 5th May 2021. This 4th May, so on the next day, he is thinking of appointing these three candidates, Mr. Sham, Ms. Devaki, and Mr. Ashok, as one of the nominees. Okay, as the nominee. So one of them will be appointed as the nominee. Mr. Sham, son of Mr. Raja, who is 15 years old, as on 5th May 2021, can he be the nominee? The answer is no, because minor cannot be a nominee or a member. Okay. Next, Ms. Devaki, an Indian citizen, sister of Mr. Raja, stays in Dubai and India. She stayed in India during the period from 2nd January 2020 to 16 August 2020. Thereafter, she left for Dubai and stayed there. Okay. Again, the only thing that we have to check is whether she's an Indian citizen. In this case, she is. Residential status does not matter anymore. So, can she be the nominee? The answer is yes. Mr. Ashok, an Indian citizen residing in India, who is presently a member of a one person company. So Mr. Ashok is an Indian citizen definitely, but he is a member of a one person company. Can a person who is a member of a one person company become a nominee in another one person company? The answer is yes, he can. Maximum a person can be member in one person company, plus he can be nominee in one person company. This is the maximum that he can stretch himself. Can he be the member in two OPCs? The answer is no. Can he be the nominee in two OPCs? The answer is no. In one OPC, he's a member, and another, he's the nominee. Is that okay? The answer is yes. So in this case, can we even appoint Mr. Ashok as the nominee? The answer is yes. And they have clearly given here that he's an Indian citizen, and residential part doesn't matter also. And they have not given anything in relation to Mr. Ashok. Easy, simple. Next one. XYZ, a one-person company, was incorporated during the year 1920 with an authorized capital of 45 lakhs. The company was the capital was fully subscribed and paid up. Okay. Turnover of the company during the year 1920-2021 is 2 crores, 2.5 crores. Promoter of the company seeks your advice in the following circumstances whether XYZ OPC can convert into any other kind of company during 21-22. Again, same thing. Can they convert into any other kind of company? Look at the number of times ICAI has mentioned this. Mock test paper April 19, revision test paper May 19, mock test paper November 20, November 2018, examination question for 4 marks. Please advise with reference to relevant provisions of the Companies Act 2013 in below mentioned circumstances. If promoter increases the paid up capital of the company by 10 lakhs during 21-22, again, paid up capital increase and all doesn't matter anymore. Can he convert? The answer is yes. So this paid up capital and turnover, all these things are not relevant anymore. Earlier they were, not now. So can we convert this one-person company into a public company? The answer is yes. Can we convert it into a private company? The answer is yes. However, can we convert it into a Section 8 company? The answer is no. Easy. Next one. Alpha School started imparting education on 1st of April 2015 with the sole objective of providing education to children of weaker society, um, either free of cost or at a very nominal fee depending on the financial condition of their parents. However, on 30th March 2022, it came to the knowledge of the central government that the said school was operating by violating the objects of its object clause, due to which it was granted the status of a Section 8 company under the Companies Act 2013. Describe what powers can can be exercised by the central government against Alpha School in such a case. Now understand, see, whenever there is a one-person company, the license that it has got to act as a one-person company, the license can be taken away if that company is doing one of these things. Okay, if it is contravening the conditions based on which it was set. So they have said here clearly that the object clause, the objects of the object, this should be object clause. Okay, due to which the status was granted to the Section 8 company, that they are violating. Okay, so they are contravening the conditions based on which the sanction to run a Section 8 company was given, or the company uh, is having its conduct done in a fraudulent manner, or the objects of the company are violated. Even this can cover this part also. The objects are getting violated, or it is prejudicial to public interest. The way it is functioning is prejudicial to public interest. Prejudicial means disadvantageous to public interest. Okay. Now, if any one of these if any one of these four conditions get satisfied, then the central government will have to send something called as written notice. Plus, it has to give reasonable opportunity of being heard to the one-person company. So sorry, to the Section 8 company. And if the Section 8 company is, not abiding by it or not following it, then the penalty provision is already there. Also, if suppose the central government cancels the license, okay, no, then what are the other things that central government can do? Central government can wind up this company, or central government can amalgamate this company with some other company. Okay, no, it can amalgamate this company with some other company. However, when they do the amalgamation, it is very important that the other company with which this company is getting amalgamated should have similar objects. Should have similar objects. So in this case, they are providing education to sections of to the weaker section of society. Can they amalgamate with a company which is providing, let's say, healthcare to elderly and such persons? The answer is no, because the objects are different. Okay, so if they are amalgamating this one-person company with some other one-person company, they should have similar objects. Okay, next one. Mr. X, in association with a relative, formed a company to promote education for the children of poor section. A license was issued by the central government, allowing the said company to be registered under Section 8 of the company. Section 8 of the Companies Act 2013. Government aids and lot of funds were contributed by public for the fulfillment of the benevolent object. Benevolent means the large-hearted object. Okay. Next, I said here, however, on the complaint against the company, central government came to know that about the manipulation of the funds in the company, and so order to revoke the license of the company was passed. Further, directed for the amalgamation, for the CG directed for the amalgamation with another company registered under this section with an object to save girl child. So CG has given the order to amalgamate this company with another Section 8 company having the object to save girl child. Examine the legal position as to the order passed by central government in the given situation in the light of Companies Act 2013. Okay. Now remember this. See, till here, no, everything is fine because they have written here manipulation of fund. Manipulation of funds can get covered here in relation to conduct is fraudulent. One of the C's here. First C was the contravene the conditions, and second C was conduct is fraudulent. So can they do so? Can they cancel the license? The answer is yes. So till here, the central government order is proper. However, they have also directed this company to get amalgamated with another company which is having the object to save girl child. Now this is not allowed. Okay, this is not allowed because this company, this Section 8 company, has the object to promote education for the children of poor section of the society. However, they are planning to amalgamate with another Section 8 company having completely different object, that is to save girl child. So this direction given by the central government is incorrect. However, the till here whatever is done is perfectly fine. You see, next one. Alpha Herbals, a Section 8 company, is planning to declare a dividend in the annual general meeting for the financial year 31st March 2021. Mr. Chopra is holding 800 equity shares as on date. State whether the act of the company is according to the provisions of the Companies Act 2013. Company is planning to declare a dividend. Okay, it is not yet declared, it is planning to. Now understand this. See, Section 8 company, by chance if they earn any profit, okay, the profit cannot be distributed as dividend. Second, by chance if they earn profit has to be used only for the objects for which the Section 8 company has been formed. They cannot transfer the profit, or they cannot distribute the money as dividend. That is completely prohibited. Okay, so here they have said whether the act of the company is according to the provision of the Companies Act 2013. Looking at the way the question is designed, they have written there the company is planning to. It means they have not yet done. So your answer will be in the lines that you will say that we'll advise the company to not to declare dividend, as Section 8 companies are not allowed to declare dividends. See, next one. A group of individuals intend to form a club, namely Budding Pilots Flying Club, as limited company to impart classroom teaching and aircraft flight training to trainee pilots. It was decided to form a LLP for charitable purpose under Section 8 of the Companies Act 2013 for a period of 10 years. And thereafter, the club will be dissolved and the surplus of assets over the liabilities, if any, will be distributed amongst the members as a usual procedure allowed under the Companies Act. Examine the feasibility of the proposal and advise the promoters considering the provisions of the Companies Act 2013. That is what they have said here. Okay. Now, how do you tackle with these questions? See, here they have said that currently they are not distributing the profit. They are saying after a period of 10 years, we are going to dissolve the company. And after dissolving the company, if there is any surplus of assets over the liabilities, it will be distributed amongst the members. That is what they have said. That is after Section 8 company dissolved. Now, tackle such questions very carefully because these are the tricky areas. Okay, see. Section 8 company cannot distribute dividend. Section 8 company cannot distribute the profit to its members. That is what it means when they say they cannot declare dividend. Also, the profit that is there, by chance, if they make any profit, by chance, they have to use it only for the objects of the Section 8 company. Okay. Now, here they have said after the Section 8 company dissolves, can they distribute among the members? The answer is no, they cannot. Why? Because otherwise, what will happen is for 10 years, even though Section 8 company makes profit, they will hoard the profit, they will keep it with themselves. And then, after the period is over for which they had started a Section 8 company, and after they have made, maybe lakhs of money with the profit, they will just dissolve the company and then distribute the profit amongst the members, which should not be allowed because it's a Section 8 company. Okay. So, hence, in this case, your answer will be saying that the members of Budding Pilots Flying Club, okay, cannot get the dividend distributed or the profit distributed amongst the members. Okay, simple. State Cricket Club was formed as a limited liability company under Section 8 of the Companies Act 2013 with the object of promoting cricket by arranging introductory cricket courses at district level and friendly matches. So they are promoting cricket. Okay. The club has been earning surplus of late. The affairs of the company has been earning surplus. Of late, the affairs of the company are conducted fraudulently and the dividend was paid to its members. Mr. Cool, a member, decided to make a complaint with the regulatory authority to curb the fraudulent activities by cancelling the license given to the company. Is there any provisions under the Companies Act 2013 to revoke the license? If so, state the provisions. Okay. Can they revoke the license? The answer is absolutely yes. Okay. Now, if the conduct is fraudulent, that is one of the as I told you, conditions should, if the conditions are contravened, conduct is fraudulent, objects are violated, and if it is prejudicial to public interest, the central government will have to send a written notice along with the reasonable opportunity of being heard will be given to the company. In this case, conduct is fraudulent is clearly given. So, can they revoke the license? The answer is yes. Whether the company may wound up, okay, so CG can take two actions. Either first is to wind up the company, or they can amalgamate the company with some other company. So one of these two things can be done. So can they wind up? The answer is yes. Whether the state cricket club can be merged with Messrs. Cool Net Private Limited, a company engaged in the business of networking, the answer is, can they merge them or amalgamate them? The answer is no, because these two companies are not having similar objects. This Section 8 company is into promoting cricket, and this private limited company is engaged in the business of what? Networking. Okay, so completely different objects. Okay. The object clause of the Memorandum of Vivek Industry Limited empowers it to carry on real estate business and any other business that is allied to it. Due to downward trend in real estate business, the management of the company has decided to take up the business of food processing activity. The company wants to alter memorandum so as to include the food processing business in its object clause. Examine whether the company can make such change as per the provisions of the Companies Act 2013. Okay. First of all, can they alter the memorandum? The answer is yes, and they're directly related to provisions in relation to section number 13. Section number 13, if you know, this is a very easy question for you to tackle. Okay, very simple. I'll do one thing. I'll cover 10A so that we are able to cover it in sections part. 13 I've just done. Question was there. We'll do 10A and then I'll be giving you one more part in relation to this portion, that is this chapter, that is incorporation of company. Okay. Mr. Dinesh incorporated a new private limited company under the provisions of the Companies Act 2013 and desires to commence the business immediately. Please advise Mr. Dinesh about the procedure for commencement of business, as laid under the provisions of Section 10A of the Companies Act 2013. Now understand this part. See, Section 10A, whenever you see, no, that is in relation to, can the company commence the business immediately? The answer is no. Why? Whenever any company is incorporated, it is a duty of any one of the board of directors to submit within a period of 180 days. Within 180 days, they have to submit some data to the company. Okay, they have to submit some data, to the ROC, and they have to submit the data in relation to whether the paid up capital has been, the shares have been fully subscribed. Okay, no, value has been paid fully by the subscribers to the memorandum or not. Okay, that is what they need to confirm. So if the company is incorporated, then within 180 days, the director has to give a declaration in this regard. Okay. Now the next part is, sir, if the directors don't give the declaration, then the company cannot commence the business. Okay. Second, there is one more condition in this, and that is in relation to the verification of the company registered office. So the company has to verify its registered office with the ROC, and this procedure also needs to be completed. Only when these two procedures are done, only then the company can commence the business. Okay. I hope this session has been useful. Okay. There will be one more part in relation to this chapter, that is incorporation of company. I'll see you soon. Take care.